Gentlemen, gentlemen and ladies and gents, introducing you to, if you haven't been introduced to him before, to the extreme and cry no more. Now, if you've never heard this song, you need to pay attention to the boys as they let you know. And we're going to let To the Extreme be in my background, not yours. They're going to be kind of low because we have a lot to talk about. That little exhale was because there's some information that you all should know, and we're going to have this discussion. You see this form right here? This is on the SATCOM website. When you go there, go to the PDF section, look in the folder that's called a legal understanding. Then you want to go to promissory notes. Then you want to go to IRS 3115 process. Then you want to go to tax credit claim. That document. Ladies and gentlemen, that's this document right here. It's completely fillable. All you got to do is put your information in. Why? Why is this document put together for anybody? Ladies and gentlemen, this is IRS tax topic 453 under bad debt deductions. Bad debt deductions is primarily for businesses, but also applies to non-businesses, but you want to do it as a business, as a sole proprietor. Why? Because as a sole proprietor, you get to claim all of the bad debt. What's a bad debt? Well, it's any money owed to you. Whether you loaned it out, whether it's from salaries, wages, rents, fees, interest, dividends, or similar items. These are bad debts, but you must show at the time that it was not a gift, that you were not gifting your time. It was not a fringe benefit. Okay? As long as it's owed to you and hasn't been paid, that means you are lending that money every single day it hasn't been paid. Are you understanding what's just been said there? Ladies and gentlemen, you may not have sat up there and said, here, you can have my money, but as long as there's an agreement for somebody to pay you, as long as somebody has an obligation to pay you, and they don't pay you, every day they don't pay you, hey, where's my money? Get back out off there on that corner. You gonna bring me my money. Okay, as long as they owe you money, every day they don't give you the money, that is considered a loan because they haven't paid you, but they owe you. Every day you are not given your money, that means you are allowing them. Yes. You are allowing them to hold on to it. So you have the right to say, hey, wait, hold on. You ain't paying me back, is you? Man, I ain't been, man, you know I ain't gonna pay you back. I ain't never promised to pay you back. None of you did promise to pay me back. Well, man, I'm taking away that promise. I mean, you should never trust me in the first place. How can you trust a crackhead? You mother. Okay, so that's how. As long as you know the individual is incapable of paying you back, you can say, hey, I forgive you. Okay, just that simple. The United States government encourages that type of forgiveness. The only thing you have to do, that form we just showed you, you have to go to this paragraph right here. Okay? This paragraph and this paragraph, these are your two best paragraphs. These are your best friends. To show that the debt is worthless, you must establish you've taken reasonable steps to collect the debt. How do you establish this? You put together a statement. What type of statement? Well, this type of statement, listen, it says where deduction for a non-business bad debt, doesn't matter if it's non-business or business bad debt, hold on, the statement must contain a description of the debt, including the amount and the date it became due, the name of the debtors, and any business or family relationship between you and the debtor. Any business relationship, shut up, okay? And the efforts you made to collect the debt. and why you decided that the debt is worthless. Because these motherfuckers can't pay. They ain't paid me all this time. They ain't gonna pay, and I can't collect in nobody's coat. And if I can't collect in court, you fools say it's uncollectible, and I can just write that junk off. You may take a deduction. See, only in a year the debt becomes worthless. So, ladies and gentlemen, if you can only take a deduction in a year, it becomes worthless. That means if you carry it forward, it can no longer be considered as a deduction, because pay attention, a deduction may only be taken in a year the debt becomes worthless. Hold on, let's do a search for this. Y'all don't mind if we search the records? Now we could go to Gabiru, not Gabiru. Well, we're going to Gabiru. We could go. Pay attention to. Now I can't even think of the name. Perplexity.ai. Okay, to have them tell us you may take a deduction only in the year the debt becomes worthless. That's IRS Tax Topic 453. How to report a non-business bad debt. You must deduct a bad debt in the year it becomes worthless. If you realize that you could have reported and take the deduction of an unpaid debt, the reason why you must take the deduction in the year it becomes worthless, because if you don't take it, then you lose. Haha, but you have the right to carry it forward. Why? Because it's a bad debt. That debt could have become bad last year. Well, what if they didn't stop paying until this year? Well, then you get to claim it this year, but you must only take it the year it becomes worthless. So what happens this year? You get credited for the year. Okay? You get credited for the year. Now notice this. You may take the deduction only in the year. See, you must take is succinct. You can't get around that. But it says you may take the deduction. Pay attention to January, February, March, April, may take the deduction. So because it says you may take the deduction, and this is the IRS, because it says you may take the deduction, that means it is not succinct. That means that, hey, hold on, I can carry it forward. Hold on, watch this. B-A-D, D, uh-oh, made a mistake. D-E-B-T. Uh-oh, made another mistake. Because I'm Russian, because I'm tired. I thought you were an American. No, I'm Russian. Okay? See, look at all these mistakes I made. Put the D-E-B-T. So let's get that D-E-B-T. Dyslexic, ain't you? Your mama dyslexic. C-A-R-R-Y. There's nothing wrong with being dyslexic, except for being dyslexic, which is a disorder that many people have. And when people make jokes about it, you shouldn't take it personal. Okay? Just like there's nothing wrong with smoking crack, except for the people who smoke crack. And so if you smoke crack and people talk about people smoking crack, you shouldn't take offense. Man, sorry. F-O-W-A-R-D. Bad debt deduction carry forward. Bad debt deduction carry forward. Bad debt carry forwards, allowing certain bad debt deductions for unpaid private label credit accounts. Debits may. Ladies and gentlemen, look at that. Deductions for the write-off of a business bad debt. Blah, 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 blah. A taxpayer may take a deduction for a business write-off. What are you doing? I didn't ask. Mike, I don't need your help, office. Get on out of here. I said I don't need your help. See, I was talking about help. Okay. You can't take a deduction for a bad debt from your regular income. That is a lie. Pay attention. Notice who's saying this. You can't take a bad debt from your regular income. That is a lie. At least not right away. Told you it was a lie. I don't read ahead. I told you it was a lie. Generally, see, there's General Lee again. Man, General Lee always showing up when the Duke's in there. Man, it's a hazard, I promise you. Okay, so now you guys understand. So let's get back to our discussion. Can we talk about it? Let's talk about it. This is, wait, where's my SATCOM? I can't find my SATCOM. Where my SATCOM at? It ain't there. It ain't there. This ain't it. Nope, that surely ain't it. This is the Ladies and gentlemen, this is the Check 21 Act. Check, please. Check 21 Act. It to be known as the Check 21 Act. See, the 21st Century Act. Check clearing for the 21st Century Act or Check 21 Act. That's where SATCOM went. Hold on. There she go. This is SATCOM. Okay, now we're back here. Ladies and gentlemen, this documents whom the credits are for. See, that's why you're doing it. This documents whom it's being assigned to. That's why you're doing it. We had the other document, but we're going to say we put everything in here. This is for you getting your credit. So you are putting together a statement and you're going to attach your statement to this. Notice this right here. Credits are analogous to tax refunds and are considered property. So you're just notifying them. Okay? Then this is your credit claim form. You're just, all this stuff is right here, letting you know what you can take a deduction for and everything. And then guess what? Right here, this is your Schedule C information telling you what you do. What do you think I would do at this moment? And then here is your notification of changing of accounting methods. And you just have to edit it and fill it out and get it on in here. And this is your usage tax worthless debt statement. Did you see that? Present this form with your usage tax return to report worthless accounts, bad debts. Ladies and gentlemen, usage tax. You pay usage tax on your home, you pay usage tax on your cars. Pay attention. It's called a usage tax. Each one of you should be filing a usage tax exemption, but you technically don't have to file a usage tax exemption if you are one of the people. They cannot presume that you are required to pay taxes. You have to volunteer to pay the taxes. And just because you don't give them notice that you are not volunteering, they cannot force you to volunteer. I know people don't understand that simple stuff, but I don't have time to explain it in its finite details. What you must understand, they cannot take away a right from you. You don't have to announce to them, I'm exercising this right. Just like when the police say you have the right to remain silent. That's not your right. There is no such thing as a right to remain silent. It's presumed you have a right to remain silent. Why is that? Because you have the right to freedom of speech. So you also have the right to freedom not to speak. That's the presumption. If you have the right to speak, you also have the right not to speak. As I've told many of you, if you've ever been arrested, the police like to tap the telephone. They like to tap the telephone at the facility of the jail and use that information to investigate you. Ladies and gentlemen, do you know that once you're an appointed an attorney, they're not allowed to question you or record what you say without your attorney being present? Nor can they use the evidence or information against you because it's not evidence. Hold on now. But you know, you sign those papers at the jail to waive your rights. You waive those rights. But then that means you waive your right to an attorney. Do you not see how they catch 22 you? So that's why you must void the contract. Oh no, they must provide the telephone system to you. They cannot tell you, well, then you have to write. Nope, sorry. If as long as you provide the system to everyone else, you cannot sit up there and put restraints on me because I decided to exercise a right. So equal protection of law says if you provide it for everybody else, you must provide it for me. Enough about that. Let's get back to this document. The reason why we are showing you this, ladies and gentlemen, today, because we need to bring something to your attention. Have you ever had a car repossessed? Have you ever had a house foreclosed on? Then why aren't you filing for your loss? Okay, there are two things we need to show you. You guys know this thing right here? This is called the Federal Reserve Act, Section 16. Okay, it's codified at Section 12 USC 411 and 12 USC 412. The only problem is, I want you all to take a look at this. You see where it says 10A, 10B, 13, 13A of this act? Okay, we're going to take a little trip. We're going to go to Cornell Law. Cornell! No, we're going to get to bank in a minute, okay? But we're going to go backwards. Man, you just been going backwards all your life. Your mama been going backwards. Don't you say nothing else about my mama. Well, then don't say nothing else to me. Okay, sorry about that, ladies and gentlemen. I want y'all to pay attention. Title 12, Section 412. Now that's Title 12, Section 412, exactly where it says this is coming from. Okay, well, the Title 12 is supposed to be coming from this, but this it ain't coming from this. I want y'all to pay attention. Pay attention. Back to Title 12. Title 12, Section 412. Pay attention to this. Any Federal Reserve Bank, and then it says collateral security, and then it says 92, 342, 348, 349, 352, 361, 372, 373, and 348A, 353, 359, 348A, 353, 359, 348A, 353, 359. Look at that. All them threes and them fours, even a couple of nines in there. Ain't that interesting? Now let's go back here. Wait a minute. Where the threes and the fours at? Where the nines at? Come on, where the threes? Oh, there go a three, and there go a four. What nines? I don't see no nines, y'all. I don't see no nines. Drop the nine, mother. Drop that nine. Don't you pick it up again. Take that clip out of that. I apologize, y'all. He just keeps getting in my way. All right, let's get back to it. Do you notice the difference? Anybody remembers the Sesame Street song? Two of these things is like the same thing. One of these things is not the same. Okay, pay attention. Nines, threes, fours, twos, threes, four, eight, threes, four, nine, 353, threes, four, eight, 353, threes, five, nine. You see? And 373, 372, 361, 352. See all those threes and them fives and them twos and them nines and them sevens. So let's go back to the Federal Reserve. No threes, no fives, no twos, no nines, no sevens. What the? How is that possible? Oh, because according to the law, the code is only prima facie evidence. Hold on, just so that you guys get it, because sometimes people don't know the code. And I said prima, but prima facie. We're going to do facie, not facie or facie. So y'all hold on. Hold on. See, it wants to do facie. Fossy? No, facie. Facia? Facie. Okay. It is prima facie. It's prima facie lawful. This is a question somebody asked. No, we're not doing is it lawful? We're doing what is it? The meaning of the term prima facie or prima facie, okay, or prima face. Prima face. Try it. It works like magic. What does the term prima facie mean? This is a law review, and they say an objection from the average stockbroker continues in itself a prima facie case for any social reform. That doesn't make no sense. This is some George Bernard Shaw. Pay attention. The term prima facie or prima facie occurs in almost 200 Louisiana statutes, but it is not defined in any of them. There are a number of different uses of the term in Louisiana and in the common law jurisdiction. No, not in the common law. That's in the court's common law. Let's continue, shall we? In the next few pages, this comment will examine the development of the doctrination of the term prima facie in various disciplines, especially in the law, and over many years. The goal is to discover that the meaning that should be given to the term prima facie evidence, so the confusion might be reduced. Ladies and gentlemen, do you understand? Prima facie it's not contained nowhere in the Constitution. Okay, not contained anywhere in the Constitution. It is not law. So prima facie, the code is prima facie. Did you not remember when I typed that in? The code. Now we're going to put, watch this. Uncle Sam. That's what US stands for, Uncle Sam. What, y'all didn't know that? Okay. The history leading to the first edition of the U.S. Code in 1926 and the decision that it would be only prima facie evidence. I didn't write this, ladies and gentlemen. Hold on. They created this. I like it though. I really do. You have my word. I like it. I like what's being said here. This is an abstract. Abstract what? Abstract judgment? Accept all cookies. Y'all must be out of y'all mind. I don't know nothing about no cookie cream. Hold on. Where the cookie list at? I don't want neither one of them. We do strictly necessary because we do strictly business. You know what I'm saying? Tell me no performance, mother. Apologize, ladies and gentlemen. As a practical matter, most researchers, legal researchers, rely on the United States Code or on the annotated code, USCA, United States Code Annotated, rather than the United States statute at large. Now, hold on, ladies and gentlemen. Do you see how they say they rely on the code rather than the statute at large? Well, you guys got to start highlighting the error in the code so that they can't use that no more. And yet, the section of the U.S. codes are not laws that Congress enacted or the president signed. Who's writing this? Man, this sounds like something I would write. Man, this sounds like something I would write. Man, I don't know who this person is, but I give them some credit. That's exactly what I would tell y'all. This paper discusses several topics related to the U.S. Code. The circumstances when the courts turn to statutes over U.S. codes. The history leading to the first edition of the United States Code in 1926 and the decision that it would become prima facie evidence of the law. The progress of enacting titles as positive law, only the titles beginning in 1941, and the new titles that are in the works. Ooh-wee! Ain't that something else? It says download, but I know it's going to ask me for my name and number and my license plate and my height and my age and my weight, and it didn't do that. So, ladies and gentlemen, I will put this link underneath the video because anytime you guys are going into court, they're always trying to bring a code. A code. So, what we need you to do is we need you to understand that the code is not law, it's a code. It tells you right there on its face. I'm a code, and I'm just a code, and I got as far as Capitol Road Island. Well, now I went to the I'm sorry. Uh, nowhere in the song "I'm Just a Bill" do you guys see the code. The code was not enacted by Congress. This will give you a very basic understanding. I remember this paper. I've had it before because I remember this before. But as I tell you, let's see when Miss Mary Jane, I love her just the same. Let's see when Mary wrote this. Mary, when did you write this? You don't know? Well, I don't know either, Mary, but let's look at some dates. That's 209. Okay. So at least 209. Because 209 that it wouldn't have 209 in there if it hadn't happened already. You know what I'm saying, Burn? All right. Where's some old? That was 209. I ain't gonna look through the whole thing, y'all. I just need y'all to understand that at least 209 is the document. I'm not. It's not that important. So y'all ain't got to do no research on it. You just need to know that she backed it with case law. As a matter of fact, every court you go into, bring a copy of this. Oh, it's only 12 pages, so copy it front to back. And what I would do if I were you, I would simply put it on the record. Okay, Lawberry Journal. Okay, Law Library Journal. Yeah, 209. Ha ha. So 2009. You kind of just locked up there from the beginning. I didn't see that at the beginning, mother. All right. So now we have this, and I'll leave this up so I can give you guys that. We're gonna go backwards, okay? Because we can't go forward no more. So as we showed you, the code does not match the act of the Federal Reserve. So we can't go by the code, and that's what you produce. You produce that this junk is bull. Excuse me. Okay. Now, what about this? Federal Reserve Act Section 16, that's on the Federal Reserve website. What about this right here? I want y'all to pay attention. Now, we've seen 10, AB, 13, A, and then 14. Okay, so 10, AB, 13A, 13, and 14. Okay, just that simple. See, just a couple of numbers. It's not even a lot of numbers. 1, 2, 3, 4, 5, 6, 7. 1, 2, 3. 1, 2, 3, 4, 5, 6, 7. Only 7 numbers. 7 numbers. You know that's got to be important. Okay, so we got 7 numbers. Let's see. Not this one. We Ricola. Ricola. We'll talk about this in a second. Let me see if I can pull up the stat for y'all. This is the statute at large, ladies and gentlemen. This is 59 Stat 237, subsection numeral 2. 59 Stat 237, subsection numeral 2. I want y'all to pay attention. Federal Reserve Bank. Any Federal Reserve Bank may make an application to the Federal Reserve agent for such an amount of Federal Reserve notes as here and before provided, as it may require. Okay, 13, 14. Wait, hold on. Let's see. 1, 2, 3. Hold on. Hold on. Wait, there's got to be more than 3. The other one had 7. Okay, let's start here. 1, 2, 3. Hmm. The other one had 7. Wait a minute. 1, 2, 3. Wait a minute. Hold on. That can't be. Where you at, Federal Reserve? Get off of that one. Get on over here to Federal Reserve. 1, 2, 3, 4, 5, 6, 7. Yeah, 7. But how could that have 7 and this have 7? So, ladies and gentlemen, the Federal Reserve on their website, that's not law either. Now, the statute at large is only prima facie evidence of what the law is. It is presumed to be the law. Okay? It's not the law. The supreme law of the land is not the statute at large. Supreme law of the land is the Constitution and its limitations on government. That's the first thing you should know. So when you go into anybody's court and they want to use a code, you tell them that the code is fallible. The code is fallible. There are too many mistakes in the code, and the code does not match the statute at large, or the code does not match the official bill. If you're on a state level, legislative bill. The code is not written by Congress, so that means it is not part of the legislative process. Remember that phrase, legislative process. That's your best friend. So let's get back to talking. I had a guy who I did a consult with. He told me he went into bankruptcy court, and the bankruptcy court trustee told him that that was that sovereignty stuff, and that was that fake law stuff. Ladies and gentlemen, let me do y'all a favor. A trustee is not a lawyer. Trustee is not a judge. A trustee is just that, a trustee. So I haven't filed bankruptcy Schedule C's and bankruptcy Schedule F's and bankruptcy schedules anything. But I do know that none of your loans are ever secured. Ladies and gentlemen, once you tender the collateral security, which is for the total amount of the notes applied for, you've done your job. You've tendered payment. So there is no security for the loan. Your security was your note. So there is no security for the loan. Now, getting back to the reason why I'm doing this video, those points I needed to point out to many of you because many of you didn't know this. Now, hold on now. We ain't finished. We's ain't finished. The fact that you know that, ladies and gentlemen, the Federal Reserve Act has been around for, all of them say any Federal Reserve Act. All three says any Federal Reserve Act. This has been around since 1933, at least 1935 as amended. Ladies and gentlemen, we're going to do it again. Let's do it again. Let's do it in the morning. Reserve Bank. Reserve Bank is under the term bank. That's why it says Reserve Bank here, and it should have the meaning as in 221. We click on this one, and it will bring us here. However, the very first paragraph tells us about 221. This is 221A. As you can see there, we need 221. So we're going to click on this one to get to 221. I want y'all to pay attention. Wherever the word up. Okay, this is talking about the word bank. So we can't consider this. Why can't we consider that, homie? Because whenever the terms, so we're dealing with terms, not words. So we can't consider that first paragraph. Oh, that makes a sense. Got to keep the subject matter. The terms, so the second paragraph is our focus. National Bank and banking association shall be synonymous and interchangeable. So, okay, fine. That's not talking about what we need. The term member bank shall be held to mean any national bank, state bank, or bank. So it means any bank. Well, what's a bank? Can anybody tell me? Can anybody tell me? Let's go to section number 3 of the Act. We got to zoom. Nope, we're going to zoom. Okay, ladies and gentlemen, section 3 of the, pay attention, the Check 21 Act. Check, please! Okay, Check 21 Act, ladies and gentlemen. You know, you got some issues, homie. No, I don't have any issues. I'm actually tired and I want to go lay down because I've been watching the TV series. It's a little mini series called We Own This City! We own this city because of rock and roll! An HBO series. Ladies and gentlemen, under Section 3, definitions, bank. The term bank shall mean any person that is engaged in the business of banking. Ta-da! Any person. So, Federal Reserve says that this any Federal Reserve Bank only applies to Federal Reserve banks and not to persons. They say it would never apply to persons. Really? Congress would never do that? Apparently, any person is what they said the word bank applies to. So I guess it fits the definition of any Federal Reserve Bank. Hold on now. It says any Federal Reserve Bank. So we got to understand any. So any is a determiner. I clicked off of it. So let's do ANY is a NEGATIV. Uh-oh, that's an NVERDETERM. Let's see what it is. Any. We're looking for determiners. This one is going to be the one that we clicked on earlier, but I want negative determiners. Let's do English grammar number 2. I haven't clicked on this today. I did discuss this with someone earlier. Whoa! A security risk. Go back! Go back! Don't go forward! It's too late! Oh, you gonna get them pop-up-em-ups! And would just shut up. Negative determiners. Why would you not want me to see this? Hold on, y'all. We use negative determiners in positive sentences to emphasize a negative idea. The most common use are no, none, nobody, nothing, anybody, anywhere, no one, nowhere. None of comes before none of. None of you have anything to, comes before a determiner or a pronoun. Ladies and gentlemen, there is no way he is a Capricorn. None of the past nights had a full moon, but yesterday did. Nobody in the class knew about the Big Dipper because they were stupid peons. Nothing shines brighter than the sun. What you mean nothing shines brighter than the sun? Please, a supernova shines a whole lot brighter than the sun, you moron. There is no one that wanted to join him climb the mountain because it was an anthill. There is nowhere More, there is nowhere more beautiful natural scenery than this. You need to get that camera out the crack of your anus. I'm sorry. Um, let's continue, shall we? It doesn't have any. Oh, I don't see anybody. It doesn't have any though. And I just needed to give us the example of an anybody. Ah, it says advertisement, and it says it's a warning. And I don't see why it's a warning because let's see, do y'all got the lock? Connection not secured. Oh, so that's why you did that because it wasn't secured. Well, that's okay. We gonna unsecure it anyway. Negative determiner. This one has any. Went to this one earlier today, so we're gonna go here again. Any as a determiner. We use any before a noun to refer to an indefinite or unknown quantity or unlimited entity. Ladies and gentlemen, why did they do that? Did you bring any bread? Mr. Jacobson refused to answer any questions. If I were able to travel back to any place in time and history, I would go to the ancient nation known as Achin. That's right. Anyway, ladies and gentlemen, any is a what's known as a negative determiner, and it is to demonstrate unknown quantity, unlimited, indefinite. So it includes everything. So includes doesn't necessarily mean exclude. So this is an inclusive term, i.e., a negative determiner. Any Federal Reserve Bank means any bank. Any bank means you, as long as you conduct banking business. We can't use this one, so we have to go to the original, the statute at large. Any Federal Reserve Bank, the local Federal Reserve agent. Such application shall be accompanied by a tender to the local Federal Reserve agent. The collateral security that's offered shall be notes. In event, no event shall such collateral security be less than the amount of Federal Reserve notes applied for. Ladies and gentlemen, the a let's see, the a trying to think of all the positive determiners that are here. But I know the and a are specific positive determiners. They actually identify a pronoun, person, place, or thing. Okay? They identify. So this negative determiner is deals with statutory interpretation. Doesn't matter what the courts say. They cannot disprove this. They cannot tell you that the any didn't include it because guess what? Hold on. Hold on. Cause I's coming. Presidential Proclamation 2039. As used in this order, the term banking institution shall include all Federal Reserve banks, national banking associations, persons engaged and transact in any other form of banking business. The term banking institution means banks and persons engaged in business of banking. Uh-oh. That's Presidential Proclamation 2039. Now let's see what Congress had to say as well. We're going to enlarge this just a little bit. Just a little bit. Just a touch of love. Just a little bit. Just a touch of love. Okay, ladies and gentlemen, it says any Federal Reserve Bank may make advances to any individual, upon the promissory notes of such individuals. Okay, that came from this paragraph. This is the Federal Reserve Act. This is Section 403. Okay, see, Section 13 of the Federal Reserve Act. Wait, where did we see Section 13 before? Hold on, let's see. Well, look at that, Section 13. Wait a minute, hold on. That can't be the only place we saw Section 13. Hold on. Hold on, y'all. Y'all just trying to get ahead of yourselves. Y'all can't get ahead of y'all Section 13. Y'all can't get a Section 13. Y'all can't get a Section 13 ahead of yourselves. What? You didn't know? Ladies and gentlemen, take a look. This is Section 13 of the Federal Reserve Act. You are considered a party that may apply for advances of Federal Reserve notes. That's interesting, ain't it? So now you know. Look, ladies and gentlemen, with the amount of information I provided on video regarding this Federal Reserve Act, Many of you should be experts at this. You should be able to defend yourself and handle yourself, including the guy who went and spoke with the so-called trustee. You have the documents. We put the documents up. They're on the website in the very same section as this. You just have to look for them. I'm not going to point them all out over and over and over again because you're not going to do that to me. But this is how you need to handle that, because many of you, you would rather not let an organization like mine handle your stuff. You would rather say you can't afford it, and now you'd rather come out of the pocket and pay more by going through much, and then you're going to end up losing what you got. Some people are going to lose their homes dealing with us as well, but not going to lose them permanently. Now, here's the thing. Again, we're talking about the reason why this video was done. Many of you, many of you, many of you, many of you have lost your cars. Many of you have lost your homes. Many of you have lost your mother. You have been going through a lot. Ladies and gentlemen, uh-oh, that's case text. I didn't want case text. I want SATCOM. Same color. All right. If you've lost your home in the past, if you've lost a car, forgive the dealership. We just showed you where your promissory note was the collateral security. They were supposed to take it to the Federal Reserve agent. And if they were the local Federal Reserve agent, they were supposed to take it to the Federal Reserve. They didn't do that. So forgive them for the money portion of the loan, and do a 1099A, 1099C with you being the creditor, the lender, creditor, lender, and they being the debtor because they are indebted to you. Why? Because they are still claiming there was an outstanding debt. They took your home. Now, if there was an outstanding debt and they took the home at the same time, then you charge them double because that's two different debts. The outstanding debt, which they should have gotten the money from the Treasury, and the home. Those are two separate debts, ladies and gentlemen. And write that junk off. But I'm afraid of the IRS. What are you afraid of? You're following the law. You're documenting it. That's why this was created, so you can document it. Okay? That's why this was created. Read it, people. Don't just sit up there and fill it out. Read everything. Everything is here for a reason. This was added for a reason. Can you show us what that says? Hold on. All right, but could you hurry up? You better watch yourself. Well, you just take too long. The law clearly established that individuals have the right to pursue a chosen profession free from arbitrary or excessive government interference. This includes not imposing an excise tax on a person's right to earn a living. The right to earn a living by pursuing an ordinary occupation is guaranteed protected by the Constitution. This is not my words. This is what the courts have said about your right to earn a living and not be taxed on it. What happens is when you get taxed, you are supposed to write it off. When you get taxed, you are supposed to write it off. Okay, that's what that's there for. Please include a simple and concise statement accounting for the transaction donation event, documenting how the event took place, whom were the parties, where the events took place, when the event took place, what event took place, and the manner of the transaction, i.e., business relationship documenting intent. Ladies and gentlemen, this is what the IRS requires for you to write off a bad debt. So write up that statement, attach it to this. And when you fill out your Schedule C, fill it out correctly. And ta-da! You don't have to do the 315 form, but I would suggest you do. Okay? Okie dokie. And finally, this is the uses tax form. This was done for you all. We'll put the link in the description. We'll also put the link to that other document that we showed you earlier, where they're talking about prima facie evidence. Okay? Hopefully that will be a benefit to you guys. Now look, I gotta go. I just wanted to do this, and because I did this video, I am too tired to stay up, and it's only 5. 36. I'll be asleep in about an hour. I'm up at 4 o'clock in the morning. So this is a lot of time for me to be up, and all this thinking. It's just too much for me. So we're gonna label this taxes and Federal Reserve write-offs. So we're gonna do it something like that. All right, gotta let y'all go. Before I let you, no, you can't get nothing. Good night. Good night. Sorry, gotta go.